Hello everyone, welcome to Chandra IAS Academy. I am Ravindra Babu, Senior Faculty of Indian Polity and Governance. Today I would like to start with this orientation session. So as a Group 1 aspirant, you might have a proper plan for preparation for this Group 1 Prelims and Mains. So in this session, I would like to give you a brief idea on preparation in respect to Indian polity. So in this video, I would like to give you a brief idea on the syllabus given in Group 1 Prelims and Mains. So before going into the details of this syllabus, I would like to give you some introduction for the preparation of polity. So there are a number of books available in the market and you can access information from internet also. There are so many sources for getting information. But as you are preparing for Group 1 and you are preparing for Prelims and Mains, it is very important to understand the fundamentals of the subject. So if you see any written book, there are some issues discussed in those books without proper explanation and without any basic knowledge on the topics or the concepts. So here in this Sarat IAS Academy, we are going to guide the students to acquire knowledge from the beginning itself. So it is essential to understand the fundamentals of this subject, because till the end of our syllabus, we are going to concern with few concepts where the students has to understand the fundamental concepts of the subject. With this basic knowledge only, you can understand elaborately. See, getting information or data is different. Understanding the concepts is different. Analyzing the concepts and other aspects of the subject is different. And finally, presentation in mains is also different. So the person may have sufficient knowledge. He may have abundant information. But the objective of examination is to test the caliber of the candidate. And it is to test the presentation skills of the candidate within time and within the space provided in answer booklet in mains. So for better understanding of the subject, it is essential to understand the basics of the subject. So the candidate should understand that the preparation for mains is important, and there is no separate preparation for prelims and mains, and every aspirant has to keep a target to prepare for the mains itself. So if you go through the syllabus, okay, so briefly I would like to introduce this syllabus in front of you with a brief explanation. Okay, so in this syllabus, this is the entire syllabus for prelims, Group 1 Prelims. So there you can get the information like constitution, polity, social justice and international relations. So social justice is not in our part, but so the remaining subjects, there are 6 chapters in this syllabus for prelims, where there are some points or some topics which are so repeated in mains also. So the topics which are repeating in prelims and mains, so the students has to, the aspirants has to understand that the preparation must be in a mains standard. Okay, so that it is very easy to prepare for prelims also. Okay, so if you go through these topics in detail, the first topic begins with the Indian Constitution and its evolution. So evolution So evolution is nothing but a historical background. So historical background of our constitution. So the historical background of Indian constitution begins from the British rule in India. So this evolution part, so the constitutional evolution part begins from the British rule. So why it began from the British rule only? So earlier we have so many dynasties in India. From the ancient period we have Mauryan administration. Then there are so many kingdoms, different empires were there, right? But why we consider only the British rule as a historical background or evolution of our constitution means, so in the modern form of governments and their institutions were started in India by the Britishers only. So from the ancient period to till the end of Mughal Empire in India, we have a same type of structure, political system. A monarchical form of government was followed during various periods, and in this monarchical form, only the king is empowered with all types of powers. King is the fountain for all powers in this monarchical system. Right? So, భారతదేశంలో బ్రిటిష్ పాలనతోనే సో భారత రాజ్యాంగ చరిత్ర ప్రారంభమవుతుందని చెప్పడానికి కారణం ఏమంటే మోడర్న్ టైంలో అంటే ఆధునిక ప్రభుత్వ వ్యవస్థ యొక్క రూపాలను భారతదేశంలో ప్రవేశపెట్టింది బ్రిటిష్ వాళ్ళే. గతంలో మనకున్న పరిపాలన అంతా కూడా రాచరిక వ్యవస్థ, రైట్? రాజు లేదా పరిపాలకుడు లేదా చక్రవర్తి. సో డిఫరెంట్ టైప్స్ ఆఫ్ రూలర్స్ వర్ దేర్ వేర్ ఆల్ ద పవర్స్ ఆర్ వెస్టెడ్ ఇన్ ద హ్యాండ్స్ ఆఫ్ కింగ్. ఇట్ ఈస్ ఎ ట్రెడిషనల్ పార్ట్, ట్రెడిషనల్ టైప్ ఆఫ్ పొలిటికల్ సిస్టమ్. ఒక కన్వెన్షనల్ గా ఉన్న ఈ పద్ధతిలో కింగ్ ఈజ్ సుప్రీం. కింగ్ ఈజ్ సుప్రీం ఇన్ ద సెన్స్ ఈజ్ ద హెడ్ ఆఫ్ ద అడ్మినిస్ట్రేషన్, హెడ్ ఆఫ్ లెజిస్లేచర్, హెడ్ ఆఫ్ ఎగ్జిక్యూటివ్, హెడ్ ఆఫ్ జుడిషియరీ, హెడ్ ఆఫ్ మిలిటరీ. లైక్ ఆల్ ద పవర్స్ వర్ వెస్టెడ్ ఇన్ ద హ్యాండ్స్ ఆఫ్ కింగ్ ఓన్లీ. సో ఆ ప్రాచీన కాలం నుంచి ఉన్నటువంటి రాచరిక వ్యవస్థలో రాజే సర్వాధికారి, శాసన, కార్యనిర్వాహక, తర్వాత పరిపాలన, మిలిటరీ, అన్ని పవర్స్ కింగ్ చేతిలోనే ఉండే. కానీ మోడర్న్ ఫామ్ లో సో గవర్నమెంట్స్ ని స్టార్ట్ చేసింది బ్రిటిషర్స్. సో విత్ ద ఎక్స్పీరియన్స్ ఆఫ్ బ్రిటిష్ ఇన్స్టిట్యూషన్స్ ఇంట్రడ్యూస్డ్ ఇన్ ఇండియా అండ్ డిఫరెంట్ యాక్ట్స్ మేడ్ బై ద బ్రిటిష్ పార్లమెంట్, దట్ ఈస్ లెజిస్లేచర్ ఫర్ అడ్మినిస్ట్రేషన్ ఆఫ్ ఇండియా, they inspired our constitutional makers and they adopted and they borrowed certain political institutions and the functions of various institutions from the British legacy. So British వాళ్ళ నుంచి మనం ఎక్కువగా ఈ ఆధునిక ప్రభుత్వ రూపాలు, వాటి యొక్క సంస్థలు, వాటి పనితీరు వీటిని గ్రహించడం జరిగిందన్నమాట. So this evolution part is a historical background of our constitution. So various acts made by the British Parliament during company rule and the acts made by the British Parliament during Crown rule. So how they evolved. So what are the changes and reforms introduced in various phases. So they inspired our constitutional makers to prepare Indian constitution. So that is the reason why we consider the evolution, that is historical background of our constitution. So from British rule in India. Then coming to the features of our constitution. The features of our constitution. So normally every constitution will have its own identity and there may be some certain specific features or peculiar features. In the same way, our Indian constitution is also having a few special or peculiar features. Okay, so if you quote some of the important features like the biggest and lengthiest constitution of the world. Okay, so the combination of rigid and flexible features, then blend of unitary and federal features. Then we have other features like fundamental rights, fundamental duties, directive principles, like various features are there to our Indian constitution. So elaborately, in a broad sense, we have to understand these features. Okay, then if you go through this next topic called preamble. So preamble is a identity card to our constitution. Preamble is a brief introduction to the Indian constitution. So by reading this preamble, we can understand the nature of our constitution. We can come to a conclusion about the objectives and goals of our constitution. and we can get awareness about the aspirations of our constitutional makers. So it is a brief introduction to our constitution. By reading this principle, the feature, this preamble, we can understand the important nature of our constitution. We can understand the source of authority of our Indian political system also. So the Praveshika లేదా పీఠిక అనబడేటువంటి ఈ ప్రియాంబుల్, సో ఇది రాజ్యాంగానికి ముందు మాట లాంటిది లేదా క్లుప్తంగా వివరించబడినటువంటి ఉపోద్ఘాతం లాంటిది, ఇంట్రడక్షన్ పార్ట్ అన్నమాట. సో ఈ ప్రియాంబుల్ని అధ్యయనం చేయడం ద్వారా, చదవడం ద్వారా రాజ్యాంగం యొక్క లక్ష్యాలు, రాజ్యాంగ నిర్మాతల యొక్క ఆశయాలు లేదా భారత రాజకీయ వ్యవస్థ యొక్క అధికారానికి పునాది ప్రజలు అనే విషయాలు మనం సులభంగా గ్రహించగలుగుతాం. So the terminology used in this preamble, so it is having a lot of explanation, and there are various types of provisions mentioned in the constitution, but in brief manner. So we are going to study this preamble, which begins with we the people of India having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, like this. Every word used in this preamble is having a lot of importance. So it is having a lengthy discussion in our constitution. Many provisions related to these terminologies were mentioned in the constitution. So the questions may be given from this part of preamble. So this preamble, other controversy also arose that whether the preamble is considered as an integral part of our constitution or not. The Supreme Court itself declared its opinion on the nature of this preamble. So in Berubari case, it is observed that the Supreme Court opined that the preamble is not an integral part of our constitution. But this kind of judgment was suspended by the Supreme Court in Keshavananda Bharati case, and it declared that preamble is an integral part of our constitution. So the status of preamble is also very important to understand, because the question may be given from this part of preamble. ఓకే, ఈ రాజ్యాంగ ప్రవేశ యొక్క స్వభావం ఏంటి, ఇది రాజ్యాంగంలో అంతర్భాగమా కాదా అనే విషయంలో సుప్రీంకోర్టు ఇచ్చినటువంటి తీర్పులను కూడా దృష్టిలో పెట్టుకొని అధ్యయనం చేయాల్సి ఉంటుంది. ఎందుకంటే ఈ విషయం మీద కూడా మనకి క్వశ్చన్స్ వచ్చే అవకాశం ఉంటుంది. ఓకే, దెన్ నెక్స్ట్ ఫండమెంటల్ రైట్స్, another important topic for examination point of view. So the fundamental rights are essential for the overall development of individuals. So these fundamental rights they mentioned in part 3 of our constitution, and articles 12 to 35 they deals with the fundamental rights. ఓకే, ప్రాథమిక హక్కులు అనే భావన గురించి రాజ్యాంగంలో 3వ భాగంలో ఆర్టికల్స్ 12 నుంచి 35 వరకు ఈ ప్రాథమిక హక్కులను ప్రస్తావించింది. రైట్, సో ద ఫండమెంటల్ రైట్స్ ఆర్ ద బేసిక్ ఆపర్చునిటీస్ గ్రాంటెడ్ బై ద కాన్స్టిట్యూషన్ టు ద పీపుల్. దే ఆర్ ద బేసిక్ ఆపర్చునిటీస్. They are essential for overall development of individuals. So in all aspects, the individual progress can be achieved by the individuals by utilizing these opportunities mentioned in the name of fundamental rights. వ్యక్తి యొక్క సర్వతోముఖాభివృద్ధి లేదా ఔన్నత్యం అనేది ఈ ప్రాథమిక హక్కుల ద్వారా సాధ్యమవుతుంది. When an individual was granted this freedom to enjoy his life, he was provided an opportunity to develop personally. Whatever may be the context, politically, socially, economically, educationally, culturally, in all aspects, an individual can develop, individual development can be possible when the state is providing these fundamental rights. అన్ని రంగాలలో వ్యక్తి అభివృద్ధి అనేది ఈ ప్రాథమిక హక్కులు వినియోగించుకోవడం ద్వారా సాధ్యమవుతుంది. So because of this reason, these fundamental rights are provided, so they are justiciable in nature. They are justiciable in nature. So they are justiciable అంటే వాటికి న్యాయ సంరక్షణ ఉంటుంది. So because of attempts made by the state or individual or any institution, if the fundamental rights of an individual are violated, then the person can approach the apex courts like Supreme Court and High Court in order to protect his fundamental rights, because they are justiciable in nature. Okay, so we are going to have an elaborate discussion on the nature of these fundamental rights, what are the limitations of these fundamental rights, how many fundamental rights they are mentioned in the constitution to restrict the state authority, because the fundamental rights, majority of the rights are negative in nature. They are negative in nature because almost all the provisions of fundamental rights or the articles in these fundamental rights, they are restricting or limiting the state activities, except 3 articles. So the 3 articles like 17, 23 and 24, these 3 articles, they are expanding the sphere of state activities, and remaining articles, they are limiting the state activities. The state should not do like this. Only 3 articles are positive in nature, but the remaining articles are negative in nature. So in the beginning, we have 7 fundamental rights when the constitution came into force. Then because of the controversy, right, and the disputes arised between the Supreme Court and the Parliament of India, right, finally Janata government in 1978, so with 40 right, so with this amendment, right, so one fundamental right called right to property was deleted from the list of fundamental rights, right. So now we have only 6 types of fundamental rights in this constitution. Okay, so we are going to learn so many things by discussing this topic, fundamental rights, because so various cases and various judgments of Supreme Court and the controversies between the cases or the judgments of Supreme Court and the parliamentary authority of amendments. So we are going to discuss all these things through which we can get elaborate knowledge on this topic. Okay, then coming to the fundamental duties, right. So when the constitution came into force, these fundamental duties were not mentioned. Okay, we don't know the exact reason why the constitution makers ignored this topic, fundamental duties. But the importance of these fundamental duties was identified by the government in 1976, and in 1976 with the 42nd Constitutional Amendment Act, on the recommendations of Sarat Committee, right, 10 types of fundamental duties were added in part 4 of a constitution by adding clause A, and 51 article by adding clause A to article 51. So these fundamental duties were incorporated in our constitution. Okay, so ప్రాథమిక విధులు అనే వాటిని ముందుగా రాజ్యాంగంలో ప్రస్తావించలేదు, కానీ వాటి యొక్క ప్రస్తావన అవసరాన్ని గుర్తించి ప్రభుత్వం 1976లో 42వ రాజ్యాంగ సవరణ ద్వారా స్వరణ్ సింగ్ కమిటీ ఇచ్చినటువంటి సిఫారసుల మేరకు సో రాజ్యాంగంలో 4వ భాగానికి క్లాజ్ ఏ యాడ్ చేయడం ద్వారా, అట్లాగే 51 ఆర్టికల్ కి క్లాజ్ ఏ యాడ్ చేయడం ద్వారా ఒక స్పెషల్ ఐడెంటిటీ ఇవ్వాలన్న ఉద్దేశంతో ఈ ప్రాథమిక విధులని రాజ్యాంగంలో చేర్చడం జరిగింది. Okay, then the importance of these duties and the committees appointed for the effective implementation of these duties were also discussed in this topic. Okay, then Directive Principles of State Policy, DPSP, and they were mentioned in part 4 and articles 36 to 51. They deals with the DPSP, Directive Principles of State Policy. Okay, so the fundamental rights, they are meant for providing individual liberties. They are focusing on the rights of individuals, whereas the directive principles, they meant for the welfare of the society. Okay, so these are the directions or the instructions given to the rulers. Okay, the rulers, they have to follow the directive principles irrespective of their political ideology. Whatever may be the political party in power, irrespective of their political agenda, okay, the parties or the rulers, they have to follow the directive principles because they meant for the welfare of society. Right, so ఈ డైరెక్టివ్ ప్రిన్సిపల్స్ అంటే ఆదేశక సూత్రాలు అనేవి రాజ్యాంగంలో 4వ భాగంలో ఆర్టికల్స్ 36 నుంచి 51 వరకు ప్రస్తావించారు. ఐర్లాండ్ నుంచి గ్రహించినటువంటి ఈ ఆదేశ సూత్రాలు అనేవి పాలకులకు ఇవ్వబడినటువంటి సూత్రాలు. సో అధికారంలో ఉన్నటువంటి పార్టీ తన యొక్క ఎజెండా పక్కన పెట్టి సో ఈ ఆదేశ సూత్రాలకు అధిక ప్రాధాన్యత ఇవ్వాల్సి ఉంటుంది, ఎందుకంటే ప్రజల సమ్మతి ఈ ఆదేశ సూత్రాలకు ఉంటుంది. ఎందుకంటే వీటి యొక్క లక్ష్యం ప్రజా సంక్షేమం, సమాజ సంక్షేమం అనే లక్ష్యంతో ఉన్నాయి కాబట్టి వీటికి ఎక్కువ ప్రాధాన్యత ఇవ్వడం జరుగుతుంది. రైట్, దెన్ if there is any dispute arises between fundamental rights and directive principles, which should be given importance or priority? So when this kind of question arises, normally we have to give importance to the welfare of the society. So the implementation of directive principles is more important than implementation of fundamental rights. So the right of a person may be violated or exploited, but the welfare of society or the community is essential. So if there is any dispute arises between the implementation of fundamental rights and directive principles, so judiciary also considers the implementation of directive principles as an important one. Okay, so we are going to have a broad understanding of these two concepts, fundamental rights and directive principles, and their the cases related with these implementations. Okay, then if you go to the next topic called amendments to the Constitution, and as per Article 368, the Constitution of India can be amended. Okay, any provision of our Constitution can be amended by the Parliament, right? And in this also, so amendment power of the Parliament also questioned by the Supreme Court in different cases. Then finally, so the Parliament is empowered to amend any provision of the Constitution by its power, but these amendments can be made by the Parliament without changing the basic structure of our Constitution. So according to the judgment delivered by the Supreme Court in Keshavananda Bharati case, the Parliament has exclusive power to amend any provision of our Constitution, including fundamental rights, but it should not change the basic structure of our Constitution. Okay, so these are the topics we are going to discuss in the preliminary point of view. Then, if you go to the next, union, states and federalism, right? So, it is a typical type of system, the federal system introduced in India by the constitution makers. The term federation or federal was not used anywhere in the constitution, but the system was established by the constitutional makers. Okay, so this federal structure was introduced according to that, right? There will be two levels of government. One is at union level, another one is at a state level. Existence of two levels of government is mandatory. As per the constitution, these two levels of governments will be there in a ఫెడరల్ ఫార్మ్ ఆఫ్ గవర్నమెంట్, రైట్? ఈ ఫెడరల్ సిస్టంలో సమాఖ్య విధానంలో రెండు రకాలైన ప్రభుత్వ వ్యవస్థలు తప్పనిసరిగా ఉండాల్సిందే. రాజ్యాంగబద్ధంగా ఈ రెండు ప్రభుత్వ వ్యవస్థలు ఉంటాయి. ఒకటి జాతీయ స్థాయిలో యూనియన్ గవర్నమెంట్, కేంద్ర ప్రభుత్వం అని, ఇంకోటి ప్రాంతీయ స్థాయిలో రాష్ట్ర ప్రభుత్వంగా ఏర్పాటు చేయడం జరుగుతుంది. నౌ అండర్ దిస్ హెడింగ్ we are going to discuss the functions and responsibilities of union government. Right, so clearly in our constitution, the powers and functions of union government were mentioned. According to that, the union government has to perform its functions and responsibilities. Then we are going to discuss the functions and responsibilities of states also. So as I said, this federal system contains two levels of governments, national and state level. So their functions and responsibilities were clearly mentioned in our constitution. So according to those provisions, the union and state governments are going to perform their duties. Then we will have a discussion on parliament and state legislatures, their structure and functions, right? So parliament is a legislature at national level. So the national or union level legislature is named as parliament, and every state, right, we have a state legislature also. So the composition or the structure of these legislative bodies will be there. So there are some slight differences between the structuring of parliament and state legislature, right? In this regard, we are going to discuss the two types of legislative structures, like unicameralism and bicameralism. So unicameralism is a type of legislature where only one type of house or one chamber will be there in the legislature. So it is known as a unicameral system. Okay, eka sabha paddhati ante okate sabha untundi, right? So but in case of national level, we have parliament. It is following this bicameral system. Bi means two, existence of two types of chambers or two levels of houses, like upper house and lower house. So existence of two chambers or two houses will be there in the legislature is called bicameral system, right? Dvisabha vidhanam antam, rendu sabhalu untayi, ego sabha digo sabha. So the composition and structuring of parliament is based on bicameral system, where we have upper house called as Rajya Sabha and lower house known as Lok Sabha. Existence of two houses. But coming to the part of state legislatures, so most of the states in India, almost 21 states are having only unicameral system, only one house, that is lower house, called Legislative Assembly. Okay, and only 7 states are having this upper house called two houses system. Bicameral system is followed in nearly 7 states, and in those 7 states, upper house is called as Legislative Council and lower house known as Legislative Assembly. So there are advantages and disadvantages with this system, and we are going to discuss and getting an idea about the parliament and state legislatures and their composition part. Okay, then parliament and state legislatures, their functions, right? Basically, they are the legislatures. The basic duty of legislature is to make laws. Legislation is the duty. So apart from that, these legislative bodies at national level called parliament and state assemblies also performing certain other functions also, right? These functions are going to be discussed here. Then parliament and state legislatures, powers and privileges, right? There are certain exclusive powers given to these legislative bodies in order to perform their functions, and certain privileges are also given to the members of these houses. Okay, so arbitrary activities like okay, and some privileges like amenities are provided to the members of houses, like right, apart from the salaries and other benefits. So some other privileges were also provided to these members. All these things we are going to discuss in this part, right? Parliament sabhyulu లేదా శాసన సభ్యులకి సో జీతభత్యాలతో పాటు కొన్ని సదుపాయాలు కూడా కల్పించబడతాయి. సో వాటి గురించినటువంటి వివరాలని కూడా ఇక్కడ అధ్యయనం చేయడం జరుగుతుంది అన్నమాట. Okay, then issues and challenges in federal structure. So other important controversial issue is that there are so many issues and controversies or challenges happening in the federal system. It is nothing but the disputes arising between center and states, right? So as per the constitution, even the division of powers happen between the center and states. There is a possibility from the beginning itself certain types of disputes are arising between central and states, because the union government was made as a strong central government by the constitutional makers. So the union government is directing the state governments in certain matters in order to achieve uniformity in administration or to implement some national policies at the state level. Okay, some state governments are opposing the domination of central government. So such kind of disputes are arising. So these are the challenges in federal system. So to overcome these kind of challenges, what are the structural arrangements made by the constitution, right? What are the statutory bodies created to establish a kind of coordination between central and states? All these things are discussed in this part and matter. ఓకే, ఈ ఫెడరల్ సిస్టంలో ఏర్పడేటువంటి వివాదాలని పరిష్కరించడానికి ఉన్న మెకానిజమ్స్ ఏంటి, అవి ఎట్లా పనిచేస్తున్నాయి, రాజ్యాంగపరంగా ఉన్నవి ఏంటున్నాయి, అలాగే చట్టపరంగా ఏర్పాటు చేసినటువంటివి. సో వీటి ద్వారా ఎలాంటి కోఆర్డినేషన్ లేదా సమన్వయం సాధించడానికి అవకాశం ఉందనే విషయం మీద సో డిస్కషన్ ఉంటుంది అన్నమాట. దెన్ డివల్యూషన్ ఆఫ్ పవర్స్. డివల్యూషన్ ఇస్ నథింగ్ బట్ సో ట్రాన్స్ఫరింగ్ పవర్ ఫ్రమ్ హయ్యర్ లెవెల్ టు లోయర్ లెవెల్. Okay, so in order to reduce the burden of central government, certain powers are devaluated, అంటే వాటిని క్రింది స్థాయి ప్రభుత్వాలకు కొన్ని బదిలీ చేయడం జరుగుతుంది. దట్ ఈస్ కాల్డ్ as devolution of powers. So to reduce the burden, right, కేంద్ర ప్రభుత్వం యొక్క పనిభారం తగ్గించడంతో పాటు స్థానిక ప్రభుత్వాల యొక్క సో పనితీరును మెరుగుపరచడానికి వాటికి బాధ్యతలు అప్పగిస్తూ సో ఈ డివల్యూషన్ అంటే వికేంద్రీకరణ విధానాన్ని వీళ్ళు పాటించడం జరుగుతుంది. రైట్, డివల్యూషన్ ఆఫ్ ఫైనాన్సెస్, ఆర్థిక వనరుల యొక్క సో వికేంద్రీకరణ కానీ, రైట్, అండ్ లోకల్ లెవెల్ ఛాలెంజెస్ అంటే స్థానికంగా ఏర్పడేటువంటి సవాళ్ళు ఏమున్నాయి, వాటిని ఎట్లా పరిష్కరించడానికి మెకానిజమ్స్ ఉన్నాయి. సో ఆల్ దీస్ థింగ్స్ వీఆర్ గోయింగ్ టు డిస్కస్ ఇన్ దిస్ యూనిట్ అన్నమాట. సో ద నెక్స్ట్ topic is constitutional authorities and Panchayati Raj. Right, so the constitutional mechanism was established by the constitutional makers, right, in order to reduce the burden of the governments, right? Some independent constitutional bodies were created by the constitution in order to reduce the burden of the governments and to act independently in certain aspects, right? So these constitutional authorities like COG, right, and UPSC, right, and Finance Commission of India, okay, then Interstate Council, okay, and national commissions for SCs, STs, the BCs, like that, right? Some arrangements were made by the constitution. Constitutional authorities or constitutional bodies, they are functioning in India. So these bodies, how they perform their functions, how they utilize their powers and functions, right? So these things we are going to discuss in a broad manner, and their responsibilities, basically what is the purpose of these constitutional authorities, right? And the Panchayat Raj institutions in India, the local bodies, right? With the 73rd Constitutional Amendment Act of 1992. So how the Panchayat Raj institutions started in India as the constitutional bodies, right? And before 1992, what is the status of these Panchayat Raj institutions which were introduced in 1959, right? After the recommendations of Dr. Balwant Rai Mehta Committee. So how they evolved and what is the progress happened and what is the failure of these local bodies, like all these things we are going to discuss as a part of this. And this is the another important area where the multiple questions can be given from this point, right? So Panchayat Raj Samsthalu ante the స్థానిక గ్రామీణ ప్రభుత్వాల యొక్క ప్రాధాన్యత గురించి మనం చర్చించుకోవడం జరుగుతుంది. సో 1959లో ప్రారంభమైన తర్వాత 1992 వరకు ఈ స్థానిక ప్రభుత్వాలు, గ్రామీణ స్థానిక ప్రభుత్వాలు ఎలా మార్పులు చెందుతూ వచ్చాయి, అవి ఏ విధంగా నిర్లక్ష్యం చేయబడ్డాయి. అలాగే సో 1992లో పివి నరసింహారావు ప్రభుత్వం అధికారంలో ఉన్నప్పుడు 73వ రాజ్యాంగ సవరణ ద్వారా సో చట్టబద్ధత కల్పించిన తర్వాత వచ్చినటువంటి మార్పులు ఏమిటి, ఇలాంటి విషయాల గురించి ఇక్కడ చదవడం జరుగుతుంది. Then we will have a discussion on public policy and governance, right? The government is going to prepare the policies for various sectors like agriculture sector, right? Public policy is nothing but the policy of the government, public and the government, right? Government policy towards a particular sector, right? So the welfare mechanism is established in India. So well-being of all the people belongs to different communities is the basic responsibility of government. Okay, so in order to fulfill its responsibility, the government is making different types of public policies like so irrigation policy, health policy, welfare policy, education policy, like different types of policies are made. There is a linked with the governance. So governance is nothing but a kind of managing affairs to implement these policies. So what kind of mechanism is established in India to implement these public policies to achieve the basic objectives of the government? Okay, so ప్రభుత్వ విధానము మరియు పరిపాలన, రైట్? ప్రభుత్వ విధానాలు వివిధ రంగాల కోసం ప్రభుత్వ విధానం వెల్లడి చేయడం జరుగుతుంది. గవర్నమెంట్ మారిన ప్రతిసారి కూడా విధానాల్లో మార్పులు రావచ్చు, రైట్? గతంలో ఉన్నప్పుడు నెహ్రూ విధానం వేరేగా ఉండేది, ఇందిరాగాంధీ కాలంలో మరికొన్ని విధానాల్లో మార్పులు వచ్చాయి. అలాగే 1978 ప్రాంతంలో కమ్యూనిస్ట్ పార్టీలు అధికారంలోకి వచ్చిన తర్వాత జనతా ప్రభుత్వం ఏర్పడినప్పుడు వాళ్ళ విధానాలు భిన్నంగా ఉన్నాయి. తర్వాత సో బీజేపీ గవర్నమెంట్ అధికారంలోకి వచ్చినప్పుడు వాళ్ళ విధానాలు, ఇట్లా గవర్నమెంట్ మారిన ప్రతిసారి విధానాల్లో మార్పులు వస్తూ ఉంటాయి. సో ఆ మార్పులు, హౌ ద చేంజెస్ ఆర్ ఇంట్రడ్యూస్డ్ ఇన్ ఇండియా and what basis the government is changing its public policies, all these things we are going to discuss in this part. Then coming to the next so LPG reforms and government bodies, right? LPG reforms, very popular concepts after 1991, right? So liberalization, privatization and globalization, the new economic reforms introduced in India, right? They brought a lot of change in the administrative strategy of the government. Okay, so the liberalization ante saralīkarana, ప్రైవేటీకరణ అండ్ ప్రపంచీకరణ, ఈ విధానాలు నూతన సంస్కరణలు, ఆర్థిక సంస్కరణలు ప్రవేశపెట్టడం ద్వారా సో దేశంలో పరిపాలనా విధానంలో చాలా మార్పులు వచ్చాయి, రైట్? సో ద ఇంపాక్ట్ ఆఫ్ దీస్ LPGs in Indian administration will be discussed in a broad manner. Okay, so liberalization is a policy followed by the government after 1991, right? So by expanding its open policy to introduce the investors of foreign countries to invest in Indian market. Okay, so earlier there are so many restrictions for the foreign investors. So with the liberal policies, the government so they reduced their authority over the market system, they opened the market for private investors, right? So to improve the economy and to get this kind of development in terms of competition coming from the other foreign countries, right? So this kind of liberalization policies were introduced, and privatization. So privatization is a part of LPG new economic reforms, right? So privatization and privatization, so the government want to reduce its burden in financial matters. There are so many sick units working under the government, right? So maintenance of these sick units is a great financial burden to the government. To reduce this kind of financial burden, the government tried to privatize these sick units, because privatization makes the private management to improve the standards of these institutions. Okay, so ఈ ప్రైవేటీకరణ ద్వారా ప్రభుత్వ రంగంలో ఉన్నటువంటి సో దివాలా తీసేటువంటి సంస్థలన్నీ కూడా ప్రైవేట్ రంగానికి అప్పగించడం ద్వారా వాటిని అభివృద్ధి చేయడానికి చర్యలు తీసుకోవడం జరుగుతుంది. అండ్ గ్లోబలైజేషన్ ఈజ్ అ కాన్సెప్ట్ లైక్ ఇంటిగ్రేషన్ ఆఫ్ అవర్ లోకల్ మార్కెట్ విత్ ఇంటర్నేషనల్ మార్కెట్, రైట్? మన స్థానిక మార్కెట్ ని అంతర్జాతీయ మార్కెట్ తో అనుసంధానం చేసేటువంటి ప్రక్రియని క్లుప్తంగా గ్లోబలైజేషన్ అంటాం, ప్రపంచీకరణ అంటున్నాం అన్నమాట. ఓకే, సో విత్ దిస్ కైండ్ ఆఫ్ ఇంట్రడక్షన్ ఆఫ్ దీస్ త్రీ types of economic reforms, so a lot of changes happened in the government administration. Okay, so వాటి యొక్క ప్రభావం ఎట్లా ఉంది వాటి గురించి డిస్కస్ చేస్తాం. దెన్ స్టాట్యూటరీ బాడీస్, రెగ్యులేటరీ బాడీస్ అండ్ క్వాజీ జ్యుడిషియల్ బాడీస్. స్టాట్యూటరీ బాడీస్ ఆర్ ద బాడీస్ క్రియేటెడ్ బై ఎ లా, right? So the parliament at the national level or the state level, so the assemblies, so they are going to create some institutions called statutory bodies like NHRC. Okay, so these statutory bodies are meant to work under the government to implement the policies and programs of the government as a legal authority or legal entity. సో ఈ చట్టబద్ధమైన సంస్థలు అన్నప్పుడు చట్టం ద్వారా ఏర్పాటైనటువంటి సంస్థలు అన్నమాట. అంటే రాజ్యాంగ సంబంధమైన ప్రస్తావన ఉండదు, కానీ అవి చట్టబద్ధమైన సంస్థలుగా తమ విధులు నిర్వర్తించడం జరుగుతుంది. అలాగే రెగ్యులేటరీ బాడీస్ అంటే నియంత్రణ సంస్థలు, రైట్? ఇన్ ఆర్డర్ టు కంట్రోల్ ద గవర్నమెంటల్ యాక్టివిటీస్ అండ్ ద అఫీషియల్స్ హూ ఆర్ ఇన్వాల్వింగ్ ఇన్ డిశ్చార్జింగ్ ఆఫ్ దేర్ ఫంక్షన్స్ అట్ గ్రాస్ రూట్ లెవెల్, సో దేర్ యాక్టివిటీస్ విల్ బి రెగ్యులేటెడ్ బై సమ్ అథారిటీస్, రైట్? సో అలాంటి రెగ్యులేటరీ బాడీస్ వాటి పనితీరు అండ్ వాటి సక్సెస్ అవుతున్నాయా, లేదా దానిలో ఉన్న మిస్టేక్స్ ఏమున్నాయి, లేదా డ్రాబ్యాక్స్ ఏమున్నాయి, వాటి గురించి చదువుతాం. అండ్ క్వాజీ జ్యుడిషియల్ బాడీస్ అంటే క్వాజీ జ్యుడిషియల్ అంటే సో అర్ధ న్యాయ అధికార పరిధి ఉన్నటువంటి వ్యవస్థలు, రైట్? సో అలాంటి క్వాజీ జ్యుడిషియల్ బాడీస్ ఆర్ ఆల్సో వర్కింగ్ ఇన్ ఇండియా సో టు implement various types of schemes and programs of the governments and for well-being of different communities in the society. So these are the topics discussed under this. Then we will have the other important aspect called rights issues, right? So we will have a discussion on fundamental rights, right? And we can understand the fundamental rights and article wise and class wise. But another important topic is rights issues, the issues of rights of different communities. Okay, so they are not directly related with fundamental rights, but these rights are also very important for the classes or the groups or the communities who are provided these rights either by the constitution or by the laws made by the legislatures. Okay, so there are some rights issues అంటే హక్కులకు సంబంధించిన అంశాలు ఉన్నాయి, రైట్? హక్కులకు సంబంధించిన విషయాలు అన్నప్పుడు ప్రాథమిక హక్కులతో ప్రత్యక్షంగా కానీ పరోక్షంగా కానీ కొంత సంబంధం ఉండొచ్చు, కానీ కొన్ని వర్గాలను టార్గెట్ గా చేసుకొని వాటి కోసం రూపొందించినటువంటి అవకాశాలని ఈ హక్కులు అంటున్నాం. సో వాటిలో ప్రధానంగా హ్యూమన్ రైట్స్, మానవ హక్కులని, విమెన్ రైట్స్, రైట్? రైట్స్ ఆఫ్ విమెన్, సో మహిళలకు సంబంధించినటువంటి హక్కులు, అండ్ ద రైట్స్ ఆఫ్ ఎస్సీస్ అండ్ ఎస్టీస్, ఓకే, షెడ్యూల్ కులాలు, షెడ్యూల్ తెగలకు సంబంధించినటువంటి హక్కులు, అండ్ రైట్స్ ఆఫ్ చిల్డ్రన్, రైట్? సో బాలబాలికలకు సంబంధించిన హక్కులు. సో దీస్ ఆర్ ద పీపుల్ హూ ఆర్ సప్రెస్డ్ అండ్ ఎక్స్ప్లాయిటెడ్ ఇన్ ద నార్మల్ society. So their rights will be protected, and separate mechanisms were also created in India in order to protect these rights of these communities. For example, NHRC, right, or SHRC, so Nation Human Rights Commission and state human rights commissions are there to protect the human rights. Okay, then we have the National Commission for Women, right? NCW is there, right? After 1992, this NCW came into force, and it is going to look after for the protection of rights of women, and we have so National Commission for SCs or STs, right? So which is going to look after the protection of rights of these communities, SCs and STs. Okay, and child rights, right? So the National Commission for Children is also there to protect the interests and rights of the children, right? So like this, these are the bodies are created, and the mechanisms are also established to protect the rights and interests of these communities. So we are going to understand all these things in this discussion. Then we will have another topic called India's foreign policy and international relations. The last topic for preliminary exam. So international relations, right? Nowadays, every country is expecting a kind of foreign countries support, right? Support of other countries, right? Because the demands and the needs of the people are making the government to maintain relations with other countries, because the resources are not available in all parts of the world with equal availability. Okay, so some places, some regions in the world, they are having rich minerals. In some parts, they are very rich in the other irrigation facilities, like that. Different types of facilities are located in different parts of the world. But needs and demands of the people made the governments to have this kind of relations with other countries to get their support. Okay, so in order to maintain these kind of relations with the foreign countries, every country has to maintain international relations. So in this regard, what is the foreign policy followed by India, right? In order to maintain, right, this relation with the foreign countries, the first time, so a proper structure to maintain relations with the foreign countries was designed by Jawaharlal Nehru. So Nehru is regarded as father of India's foreign policy. Okay, then some strategies were changed by different rulers in different courses of time, right? So ఈ అంతర్జాతీయ సంబంధాలు నెలకొల్పుకునే విధానంలో సో విదేశాంగ విధానం అనేది ముఖ్యంగా ఉంటుంది. సో ఎలాంటి స్ట్రాటజీని మనం ఫాలో అవుతున్నాం విదేశాలతో సంబంధాలు కొనసాగించడానికి అనే విషయాలు ఇక్కడ డిస్కస్ చేస్తాం. దెన్ ఇంపార్టెంట్ ఇన్స్టిట్యూషన్స్ టు మెయింటైన్ దీస్ రిలేషన్స్, దెన్ ఏజెన్సీస్ అండ్ ఫోరా, రైట్? There are special agencies and institutions were created to maintain relations with the foreign countries, right? And structure and mandate, right? How they are composed, how the officials are appointed to maintain these relations, like so the ambassadors are there, diplomats are there, right? So these officials are appointed, their terms and conditions, all those things we are going to discuss here, and important policies of foreign related aspects. Okay, so India is getting its membership in so Commonwealth countries, right? It is having its membership in other international platforms like a UNO or other things, right? So what kind of policies we are following in order to maintain these relations, right? So these are the things we discuss here. Then programs of central government and programs of state governments also discussed as a part of this prelims syllabus, right? So these are the things we are going to discuss as a preliminary part, and almost most of the topics which were covered in the mains also, right? But here in this a mains point of view, so we need to develop the knowledge and the skills to present our answer. So as I said in the beginning, so getting knowledge or acquiring knowledge is different and presentation part is different, right? So every person, every aspirant has to have their own ideology and strategy for the presentation of an answer, right? You might have seen different types of publications and books available in the market, right? So they are the opinions expressed by the writers or the authors. That is the presentation made by some of the others. So if everybody follows the same type of answers and the presentation is made in the examination, it will not give any kind of your presence. Okay, so by practicing only, you need to develop a kind of presentation of your own answer with a different type of presentation. For that, practice is required. So knowledge is also important. Statistical data or any kind of information of the concerned subject is important, but at the same time, so presentation within the time period, stipulated time period, and writing this answer within the limited space, that is also very, very important. So for this purpose, so let us see briefly about the topics mentioned in the main summary. Okay. So in paper 3 of APPSC, that is the title called Polity, Constitution, Governance, Law and Ethics. So total 150 marks is the total marks allocated to this paper, and so out of this, so you will get 50 marks from this constitution and polity. Then so from governance part we will get 50 marks, and law and ethics part we will get 50 marks. Total 150 marks paper is given in this mains. Okay, so the 150 marks and 150 minutes. Okay, 2.5 hours time is given. And if you see the important topics for this mains examination, so there are 5 important chapters. If you go through these chapters, so the complete syllabus will be like this. The first, Indian Constitution, salient features of Indian Constitution, already it is repeated in the prelims. Okay, so at the time of preparation for prelims itself, you focus on the preparation for mains. So in elaborate and broad manner, you can learn the things about the features of our Constitution. Then coming to the functions and duties of Indian Union, functions and duties of state governments. So these topics are also repeated, right? They are also repeated. So at the time of preparation for the prelims itself, if you learn the things by keeping this mains point of view, so it is very easy to prepare for this answer writing for mains also. Okay, so in mains part of view lo, so ఈ టాపిక్స్ అన్ని కూడా మనకి ప్రిలిమ్స్ లో రిపీట్ అవుతున్నాయి, మెయిన్స్ లో కూడా వస్తున్నాయి. కాబట్టి సో మనం ప్రిపేర్ అయ్యే టైంలోనే మెయిన్స్ టార్గెట్ గా పెట్టుకొని మెయిన్స్ పాయింట్ ఆఫ్ వ్యూ లోనే వీటిని ఎలాబొరేట్ గా క్షుణ్ణంగా చదివి అధ్యయనం చేసుకుంటే మనం ఈజీగా దీన్ని ప్రజెంటేషన్ చేయడానికి అవకాశం ఉంటుంది. ఓకే, దెన్ the next topic is federal structure and issues. So it is also repeated in preliminary syllabus. Federal system, I said that. So there will be 2 levels of governments, so union government and state governments. Right, when 2 power blocks are there, so the issues or the challenges may arise between these. So iland issues, so issues and challenges in federal structure. Right. Then the role of governor in states. So it is another important concept, especially given in this mains syllabus. So governor is acting as a link pin between union government and state governments in a federal system. Okay, so governor is a kind of mediator between central government and state governments. So nowadays the position of governor or the office of governor became controversial because of some attempts of some governors in different states that are in use in recent times. The decisions of governors in certain states like Tamil Nadu and other states, right? So they were questioned and challenged, and judiciary also involved in this subject, right? Now, so as a mediator between central and states, what is the position of governor? How he is acting as a constitutional head of the state, and how he is acting as a representative of union government. So on this topic, so there are so many issues and recommendations. Even Sarkaria Commission, Rajmanar Commission, they also gave so different types of recommendations on the position of this governor. Okay, so we are going to discuss this topic, and there is a chance to raise the question on this position of governor in the present dynamic situation. Okay, then distribution of power, right? Union, state and concurrent list, right? So the powers are distributed between the union government and state governments in this federal structure. So there are 4 types of lists called union list, right? State list, concurrent list and residuary list. So in the beginning, when constitution came into force, there were 97 subjects, and right now we have nearly 100 subjects mentioned in the union list. Then state list contains 66 subjects in the beginning. Right now we have only 61 subjects because 5 subjects transferred to concurrent list. And this concurrent list in the beginning contains 47 subjects. And after adding 5 subjects from state list to concurrent list, now we have 52 subjects. And residuary list, there is no fixed number for this residuary list, right? So union list subject, union list contains the subjects having a national importance. the subjects having national importance, right? The subjects having priority throughout the nation, right? So they were given to the union government. Only the union government, or means union parliament, can make legislation on these subjects. The state governments are not supposed to interfere in these subjects, right? And in the same way, the state list contains 61 subjects which are having a regional importance, or we can say local importance, right? The subjects like agriculture, irrigation, police, law and order, like that. The subjects having local or regional importance, they kept under state list, and only the state government during normal time can make legislation and take decisions on these subjects. In case of emergency, then these subjects are also operated by the central government or union government. Okay, then concurrent list consists of 52 subjects. Concurrent means both. Concurrent means both. Both the union and state governments can operate these subjects, like marriages, divorces, forests, education, judicial affairs, like that. The subjects mentioned in the union list can be operated by both the central government and state governments. Then the residuary list contains the subjects which are not included in union, state and concurrent list. They comes under residuary list. Residuary means remaining subjects. The remaining subjects which are not included in the above three lists, they comes under residuary list. In this way, clearly the powers were divided and distributed between central and states. రైట్, కేంద్రానికి రాష్ట్రానికి మధ్య అధికారాలను స్పష్టంగా విభజించడం జరిగింది. కేంద్ర జాబితా, రాష్ట్ర జాబితా, ఉమ్మడి జాబితా, అవశిష్ట జాబితాని క్లియర్ గా విభజించడం జరిగింది. So these things we are going to discuss, right, elaborately. Then issues and challenges in these divisions, right? So even after division of powers between central and states happens, even today there are some challenges. There are some issues arising between central and states on the distribution of powers. Okay, these things we are going to discuss elaborately. Then coming to the next one, local governance and authorities. So other important subject. So already the same topics are there in the preliminary part, right? They are also given in this mains, right? The Rural Local Bodies 73rd Amendment Act of 1992, right? The relevance of these rural local bodies, right? And the important provisions of the 73rd Constitutional Amendment Act after its implementation from 1993 onwards, and what are the laws made by different acts, especially it is related with APPSC. So there's Andhra Pradesh state legislation on implementation of Panchayat Raj institutions, right? So they are going to be discussed here. Then urban local governments, right? According to article the 74th Amendment Act of 1992. So the important provisions of this act and the local authorities like state assemblies and their acts, urban local bodies were created and their functioning, all these things we are going to discuss here. Then constitutional authorities and their role. So in this regard, right, local government authorities, so there are some constitutional arrangements also made under 73, 74th Constitutional Amendment Acts, like so formation of so state election commission, right, and the formation of interstate council, or formation, the formation of state finance commission. They are the constitutional arrangements came into force after 73rd and 74th Amendment Acts. So how they are working and what is the relevance of these constitutional authorities, so we are going to discuss in this chapter. Then so we are going to study about the legislature, right, and already these topics also discussed in the preliminary syllabus. So they are given in this mains also. See, the parliament and state legislatures, their structure and functioning and conduct of business, powers and privileges, issues arising, right? All these are the part of preliminary syllabus. So at the time of preparation for group 1, so we have to prepare for mains itself, because the same topics are repeating in preliminary also. Okay, then if you go to the next topic, that is judiciary, the same topic is also there in the preliminary, right? So structure and functioning of judiciary, right? So in this regard, we have to discuss about Supreme Court and High Courts, the structuring and the functioning, and emergency provisions, right? Structuring of Supreme Court is nothing but so appointment of judges, who will appoint them, who will recommend their names, and so the qualifications of judges, the terms and conditions, right, And in order to protect the independence of judiciary, what kind of measures are taken to protect the term of or tenure of the judges like this? All these things comes under structuring of judiciary. Then functions of judiciary, right? And emergency provisions during emergency time, right? What are the powers exercised by the judiciary, and constitutional amendments regarding the judiciary and its structure, and especially the BJP government introduced NJAC, National Judicial Appointments Commission, and which was intended to replace the collegium system, right? But it was suspended, and this constitutional amendment was suspended by the Supreme Court, and presently we are following collegium system only, right? So, and the judicial review power, right? How the judiciary is exercising the judicial review. As per the constitution, this term judicial review was not mentioned in our constitution, but this apex court, Supreme Court, can exercise this judicial review power to check the validity of laws made by the legislature and implemented by the executive, and till public interest litigation. And after 1980, so this concept of public interest litigation was popularized in India, right? And with this, the people, right, they can get a kind of awareness to approach the judiciary to protect the interests of different communities, right? So it is another important aspect discussed here. Okay, so in this way, we are going to have an elaborate discussion on the Group 1 syllabus, which is a part of Indian polity. Okay, so by understanding this and keeping this kind of explanation on syllabus, so I think you will be getting a kind of satisfaction, right? And come to join us to get a kind of a success in your target to achieve Group 1 officer. Okay, so all the best. Thank you.